Be seated. We are here for Court of Appeals cause number 1, CACV 150743. Andy Biggs et al. Versus Thomas J. Betlach, I believe is the pronunciation.
Betlach.
Betlach?
Betlach, Your Honor.
Betlach. Thank you. Thank you. Welcome. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen technical problems, you can critique yourself on YouTube in a couple of weeks. For everybody in the gallery, they can wonder if they really did hear what they thought they heard. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all your time. However, ultimately, your reserving of rebuttal time is up to you. We've reviewed the briefs. We have conferenced the case this morning, so we are well aware of the facts and the issues attendant to this argument, and we say that for your benefit. Please understand we have read the briefs, we have prepared, so use your time as you deem appropriate and best for your purposes. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, the appellant may begin.
Thank you and good morning. Christina Sandifer for the appellants, and I'd like to reserve 3 minutes for a rebuttal, please. May it please the court. This is a facial constitutional challenge to the statute creating a new levy to fund Medicaid expansion. Now, the material facts here are few and they're simple. The Arizona Constitution requires a 2/3 supermajority approval whenever the legislature acts to raise revenue. And it's undisputed that in this case, the statute did not receive supermajority approval in either house. So then the legal question becomes, was this statute on its face exempt from the supermajority requirement? It is not exempt from the constitutional supermajority requirement. First, because the statute on its face creates a tax. And second, because
Doesn't that beg the question, counsel? I mean, that's what we're here to decide, isn't it? Can you say automatically it is a tax?
Well, it's a tax, Your Honor, for multiple reasons, but we have to look at the face of the statute in making that determination.
Just there then, please.
Yeah, this is a facial constitutional challenge. Now, on the face of the statute, the legislature created a tax first because it's mandatory. This is something that doesn't depend on the assent of the hospitals. It doesn't depend on any action that the hospitals take. Instead, it's mandatory. And it's generally redistributive.
What's your best case for the fact that any time the state, that there's a mandated revenue required, that it is a tax?
Anytime there's a mandated revenue required, that it's...
You said it's statutory. Give me your case law is what I'm saying. If your case law for the concept that any time the state's required to raise revenue, it's automatically a tax.
Oh, no, Your Honor. I'm sorry. I'm not arguing that any time the state is required to raise revenue. I'm arguing that there are a number of factors that the state of Arizona and other courts consider in determining whether something is a tax versus a fee or an assessment. Something is a tax when it's mandatory because it's something that the payers can't avoid paying, and it doesn't rely on any type of voluntary action. It doesn't rely. The payers are not making a payment in order to get a benefit back or in order to offset regulatory costs. When it's a fee or an assessment, there is a very clear nexus between those two payments. And here,
aren't a lot of assessments mandatory?
Well, they're mandatory in the sense that, the way that I mean mandatory here, Your Honor, is that there's nothing that the hospital can do to avoid paying the tax. There isn't. This is the Jassamit case here in Arizona, actually, that the trial court relied on can help illustrate this point. But I think it shows why this is a tax rather than a fee or an assessment. So in that case, we have a state statute that required any time a pawnbroker enters into a transaction, they had to file a report with the state. And the city was required to file that report on behalf of the pawnbrokers. That meant that there was a regulatory burden placed on that city. Every single time a pawnbroker engaged in a transaction, it created a regulatory burden on the city. So the city assessed a fee in order to recuperate some of those costs. And so the court there held that this was voluntary in the sense that the fee is directly tied to the pawnbroker transactions. Each transaction places a burden on the city, and so the city asked for $3 in exchange for those regulatory
Somewhat
burdens.
similar to what we're talking about in this case, where we're talking about the hospitals being assessed this fee in order to get certain Medicaid benefits.
No, Your Honor, and this is the reason why. Here, the statute requires that the hospitals pay the tax based on income. So it's based on revenues or patient bed days or discharges. But these are any patients, not necessarily just Medicaid patients. So, for example, if I were to go to the hospital and I were to stay there for 4 days, I would be causing that hospital to pay a tax on the 4 days that I was at the hospital, even though I'm not a Medicaid patient and the hospital isn't receiving Medicaid payments directly back in exchange for that tax that it paid. And that's the difference between the nexus. So in the Jassamit case, the court noted that even if no transaction reports were filed, no fees would be required. Here, though, that's not the case. Here, the levy isn't based on any decision that the hospital makes to receive Medicaid or to receive Medicaid payments. And if no Medicaid patients are seen, the hospital's still going to have to pay the tax based on its income. The hospital operates by seeing patients generally, and that's what the hospital is making the payments based on.
But isn't that aren't most hospitals going to get a proportionate share of the Medicaid based on the total revenues that they generate?
Well, although it's true that the record, at least at the trial court level, did show that all of the hospitals that were currently paying the tax were receiving some sort of Medicaid benefits, it isn't a one-for-one relationship. And in fact, the statute is very clear that the director, in applying the statute or in collecting the tax or setting the levy, has to set that levy in a generally distributive way because he has to follow a redistributive way. He has to follow federal law. So, and federal law is very clear that this has to be generally redistributive, that the formula cannot be based on whether or not a hospital is receiving Medicaid. And it's very important because in order to be able to draw down these federal funds, the federal government didn't want it to be a situation where the hospitals are just paying to get a bunch of federal money. The situation instead is that the hospitals are paying a tax, and that purpose is going for a general public purpose. Medicaid is a public purpose. It is a government health care program. And so the purpose matters quite a bit in determining whether or not this is a tax versus a fee or an assessment. A fee or an assessment is a direct payment made in exchange for a benefit going back to, in this case, it would be the hospitals, rather than paying a tax that everybody pays based on income that is going to a general public purpose. And that's true even if the money goes into a special fund, as it does here. So in this case is a lot like the Okeson case in Seattle, Washington. There, even though a small group, they were electric ratepayers, even though a small group is paying the levy and the money is going into a special fund, it was going into the fund to fund light for the area, electricity, light, which is a public benefit. And the ratepayers weren't getting a one-for-one back in exchange for the tax that they were paying. Instead, they were paying a tax on their electric bill that was tacked on, and it was going to pay for a public benefit. And that's important, too, because it's important to know that that a levy doesn't become a fee just because there's a loose relationship between the use and the payers. There has to be a direct nexus. We can look at other cases on that. The district court in Arizona had a lobbyist tax that was levied on a small class. It was levied on lobbyists. And the court there said even though it was a small class, the money was used for a public purpose, which is to fund clean elections or voter education. So even though we have a small class and even though there's a relationship between these lobbyists who are operating in the clean election system, it's not a one-for-one. They're not offsetting any direct regulatory costs, and they're not getting a direct benefit in exchange. Likewise, the Wright case out of the Sixth Circuit that talks about the parolee tax. Here, the parolees are paying a tax, and that money is earmarked for a specific purpose, but it's a public purpose, to monitor parolees and to compensate victims. And so again, there's no one-for-one benefit, there's no direct nexus. This is money that is assessed equally among everybody in that class, and then it's going to pay for a public purpose. And that's what we have here. This isn't a fee because it's not calculated on a benefit to the hospitals, and it's, again, not calculated for the purpose of offsetting regulation. It is assessed equally among all the parties, and it goes into a fund for a public purpose. Now, it's important, the importance of the tax fee assessment distinction shouldn't be overstated. It's important because if this is a tax, because again, it's redistributive, it is mandatory, it's used for a public purpose. If it's a tax, the inquiry ends there. Because
Let me go back to public purpose.
Yes.
Which is kind of, I think, a rather an elusive concept. The record reflects that in this case, I'm going to call it a levy because I don't want to call it a tax, I don't want to call it an assessment, I don't want to call it a fee. So I'm trying to be neutral. Okay. That the levy is imposed on hospitals to provide them with funding to help care for qualified individuals. And of course, that has some general public purpose. We can't ignore that. But it's designed to specifically deal with a problem that the hospitals are facing. So how do you, I mean, you want to interpret public purpose so broadly, everything's a public purpose, but this statute was much more narrowly drawn.
No, Your Honor, I don't think I want to interpret public purpose that broadly. The statute on its face says that the purpose of this tax is, well, or levy, is to fund the non-federal share of Medicaid. And so again, it's a public purpose because that is a public program that's used to provide health care to the people of Arizona.
But the recipient, it's not an individual Arizonan.
Sure. Well,
this is designed to defray the cost of doing business with an indigent population.
Sure. Two points there, Your Honor. First of all, I think that one could liken this situation, say, to the food stamp program, for example. There, the recipient could perhaps be, Safeway or Walmart or a grocery store. They're the ones getting the money, but of course the purpose isn't to provide some subsidy to Safeway or Walmart. The purpose is to feed people. And here, the purpose is to take care of Arizona's poor by providing them with health care. And what matters is the ultimate use. And the second point on that would be that, when we think about this situation of defraying costs or the fact that hospitals are required by law to accept people into their emergency rooms and that adds costs, again, the ultimate reason for that regulation is because we want to make sure that people get health care, especially in emergency situations. Again, a public purpose, the entire regulatory scheme isn't set up in order to provide subsidies to hospitals. It's set up to provide people with the health care that the government thinks that they should have and that they need. And so because the government has decided it's more efficient in this situation to put more people onto the Medicaid program rather than having them pay out of pocket or through private health insurance, shouldn't change the fact that the ultimate purpose of this is a public purpose, and that is getting people of Arizona health care.
But doesn't your analysis leave us in a circumstance where everything is a tax? That there are no longer fees, there are no longer assessments, there are no longer allowances. I mean, in this case, we've got a director who is tasked with increasing or decreasing a fee based upon what the federal government does, right? So it's not even a fixed tax sum, and it's not based on a calculation that's established. It's based on what the federal government does. We leave it up to a director to raise or decrease this, and you're saying that's a tax. So one person in this state decides the amount of a tax?
Well, Your Honor, in fact, I think that's a concern here, why it's extremely important to make sure that we honor the voters' intent here and enforce Prop 108, because the legislature itself can't, without a supermajority, establish a tax like this. And so we shouldn't say that because the legislature just had a bare majority voting to delegate powers to an administrator, that they're getting around Prop 108 by allowing them to do that.
Do you consider one administrator to be a supermajority?
Absolutely not, Your Honor, and that's why.
Is that what happens here?
Well, what happens here, that it may be instructive to look at the word authorize, the second part of the exception here, and I actually think that's more important, regardless of whether this court determines that this is a tax or a fee or an assessment. It's still the director can only exercise his power to set the levy when he's authorized to do so by statute. So that's what the C2 exception says. And what does it mean to be authorized? Well, Prop 108 tells us that. If we look at Prop 108B5, it explains that the legislature authorizes administratively set fees by a supermajority.
Well, hold on, because
Wait,
C says
yeah.
this section does not apply if you meet one of the other criteria. So B wouldn't apply if you meet one of the criteria. So aren't you kind of really bootstrapping when you're saying authorized? I mean, there
No.
would never need to be an exception if we read if we read the Constitution.
No, Your
that
Honor,
way.
I don't believe that's true. I think the exceptions, I think this is the only way to read authorized consistently throughout Prop 108, and I think the exceptions just simply complement the overall statutory structure. And the reason I say that is because if we look at the other exceptions in subsection C, we see that they all apply, they all explain that Prop 108 applies to affirmative acts of the legislature. So if we look at C1, we see that it applies when, it does not apply rather when revenue increases because of inflation, or C3 when revenue is increased by an act of the city or a municipality or something like that. Even though if we look back at the beginning of the statute, it says affirmative acts of the legislature. It talks about acts of the legislature and supermajorities. One might not think that it would apply, that this statute would apply to cities or to inflation, but nevertheless.
Not a supermajority. Why would you need to have that be an exception in any case?
Because we're talking about two different things here. We're talking about, if it's helpful to look at Prop 108 as a whole, I guess, to think about what exactly Prop 108 is doing here. It says that a supermajority is needed if the legislature imposes a new tax, fee, or an assessment, if the legislature authorizes a new administratively set fee, and that's what happened here. The legislature created a new either tax or administratively set fee that the legislature authorized. If the legislature increases a tax or if it increases.
Hold on, let's stop right there. So they authorized it, but then you say they had to have a supermajority.
Right.
Well, it says except, subsection C says this section, the supermajority,
Right.
does not apply if, and then you go into the exception.
Right, Your Honor. It does not apply if the legislature has authorized this new administratively set fee.
Well, you wouldn't need the exception if they did it by a supermajority.
Well, but I think.
I mean, that is the most circular argument I think I've
I think
ever
what we're
heard.
talking about here, though, is who's the actor? Is the legislature creating a new statute authorizing this, or is the administrator imposing or increasing or setting a fee? And that's what the language talks about, right? When the administrator sets a fee,
But
he's
forgive me, I have to underscore what Judge McMurray said. Subsection C, this section does not apply to fees and assessments that are authorized by statute. The actor in that phrase has to be the legislature. Fees that are authorized by statute. Who passes statutes in this state? It is the state legislature.
Well, I think, Your Honor, it says and are set by a state office or agency. So I think that's what the exception is applying to. Again, once they're authorized by statute, and Prop 108 explains how they're authorized by statute by a supermajority, then when the administrator sets that particular fee, sets the amount of it, then he doesn't have to go back to the legislature and ask for a supermajority approval. I think if we read it the way that the defendants and the interveners want to read this, then we're creating a loophole that actually removes checks and balances from Prop 108. So we're saying that the legislature by a bare majority can authorize a administrator to set a tax or to set a fee or an assessment, but it would have required a supermajority for the legislature to do that itself. That seems to thwart the purpose of Prop 108, which is specifically by the voters said to put limits on the government's ability to raise revenue, even if it's difficult to respond to emergencies or court orders. This is a very, very broad proposition that the voters passed here. And so to read the term authorized out of the statute and to just say that that the legislature can hand over that kind of power by a bare majority would completely undermine the purpose of Prop 108 itself. I want to make sure that I answer all of Your Honor's questions, but I see that I only have 2 minutes left here, and I wanted to reserve a little time for rebuttal. So there are no further questions.
Thank you, counsel.
May it please the court, Doug Northup representing Director Betlach. I'm going to be making the argument today. However, Tim Hogan is here for the interveners and would be happy to answer any questions that Your Honors may have as relating to his briefing on this subject. We're here today to talk about the interpretation of the plain language of Article 9, Section 22, and specifically the subsection C2 exception for fees and assessments that are authorized by statute but are not prescribed by formula, amount, or limit, and are set by a state officer or agency.
Question. Is it necessary to obtain on all fees, assessments, and anything else the legislature passes that raises money? Is it necessary to pass it by a 2/3 majority in order to get to C2 so we can find out that a 2/3 majority isn't required?
No, not at all.
Did I misread something in the opening brief? Isn't that the argument that's being made?
The arguments being made is that you should look at the language of the C2 exception and read in authorized by a statute that itself has been passed by a 2/3 supermajority. And I think
Then why would you need the exception?
exactly. I mean, I think Judge Gerlach's reading that refers back to the statute that authorizes the assessment is really the only way to give meaning to the statute and not add words to it. And I think that, I mean, he was exactly right, and that's the position that we've taken in our briefing. The court should read this without adding words to it, and if the drafters of this initiative meant that the authorizing statute had to pass by a 2/3 supermajority, I think your point, Judge McMurdy, is why would you need the exception ever? And I think that's exactly right.
Well, and there would be nothing that involved money that would ever be allowed short of a 2/3 majority, supermajority. Isn't that correct?
That's correct. And in this particular case, the hospital assessment was authorized by 362901.08, and it's not prescribed by formula, amount, or limit in practice. But really, let's just look at the plaintiff's complaint in paragraph 2. They say under this new law, this appointed administrator has full discretion to set the amount of the tax and decide who has to pay and who will be exempt. He can and does exempt people. And there's no dispute that this is set by an officer or agency. It's never been argued that the third paragraph is not met. We've cited to the publicity pamphlet that lists university tuition, which is very analogous to our situation. The only thing I want to address on that, and I think Judge Gerlach was right, you don't really need to get to the publicity pamphlet when the language of this is clear. But the one point that the appellants make is, well, that was an example of something that was grandfathered in. The publicity pamphlet does not say university tuition was grandfathered. It says that is an example of something that meets the C2 exception. And again, that goes right down the line of where the hospital assessment fits here.
Can you analyze that pawnbroker case for us, please?
Absolutely. And one of the things, as I get into that, a point that I kept hearing counsel say, they have conflated purpose with benefit. And the pawnbroker case, the Bidert case, and the May case make clear that you're analyzing whether or not the fee or assessment is for the cost of regulating the entity or benefiting it. But the purpose doesn't really matter. The Bidert case explains that very carefully. The question is, who benefits from this? And in the pawnbroker case, that was a circumstance where they looked at it and they said, look, this is assessed on a narrow group of people.
As hospitals, such as hospitals?
Such as hospitals. There are 97 hospitals that are subject to this assessment. Out of 6 million people in the state, tens of thousands of businesses, 97 of them. And in regards to the benefit aspect of it, the record was undisputed below that out of those 97 hospitals, all but 3 of them benefit. They benefit because they are better off than providing the free care. And on a system-wide basis, every single system benefits from this. They are the direct beneficiaries, and as the Bidert case recognized, and frankly the Jachimik case, although the Jachimik case focused more on regulation of the pawn industry, again, regulation versus benefit, but the argument was made in the Bidert case, well, the real beneficiaries here are the people of the state of California, and the court said that may be an indirect benefit, but the real beneficiaries are the people that are paying the assessment, the apple producers. So in terms of Jachimik, it's on a narrow group of people. what the purpose of the money is, where it's going. In this particular case, under the second May or Bidert factor, it is the money is kept in I'm jumping to the third group. The second one is to the parties on whom the assessment is imposed. Assessment imposed on a broad class of parties is more likely to be a tax. And again, this is a very narrow group. And then as to the use of the money, there again, it was put for only the regulation of the pawnbrokers. In this particular case, the money never goes to the general fund. It cannot revert to the general fund. It is used only to fund the non-federal share of the state Medicaid program. And in regard to the benefit, again, its application is clear, but all we have to do is look at the plaintiff's own allegations in their motion for summary judgment below. And this is a quote from page 5. Evading constitutional protections and stripping the legislature of its taxing authority yields the exact outcome that Arizona's constitutional checks and balances were designed to prevent. Consolidating power in an unaccountable administrator who is free to play favorites. It ensures that the true beneficiaries of Arizona's Medicaid expansion are not the people, but the politically connected hospitals who lobby for tax exemptions and stand to line their pockets with reimbursements.
Kind of damning you by faint praise, isn't it?
Yeah, I'm not saying I necessarily agree with all the characterization, but Judge Gerlach accepted that as a binding judicial admission. But again, even if we look at the practice of it, that's the way that this has been applied. I think it's very important to note here the presumption of constitutionality of statutes. It can be rebutted, of course it can, but for example, the Arpaio case made clear in an Article 9, Section 22 case that the presumption applies. Plaintiffs, appellants admit that this is a facial challenge, but yet they don't want to acknowledge that as a facial challenge, their burden is extremely high. They have to show there is no set of application that can make it constitutional, and the Arizona Supreme Court in the Simpson versus Miller case just last week reaffirmed that proposition. And the argument that, well, Judge Gerlach recognized this as a facial challenge case but did an applied analysis isn't correct. What he did was he showed that there are ways the way it's being applied would be constitutional, and that by definition destroys any attempt at a facial challenge.
When you get to a point to talk about the exception and its application here, I have a question.
Okay.
So if you're there.
I'm ready.
You ready? Okay.
Yes.
Under the exception that applies here, there's a statutory construction argument that the formula is really a state-imposed formula, for lack of a better term, rather than because of the way the statute is written, if I explained that correctly. And I understand that. As I understand the appellant's argument, they argue that, well, the Medicaid statute at issue here basically incorporates by reference a federal Medicaid regulation that imposes a formula. Now, putting aside that argument may not square with the language of the statute, just putting that aside. Having looked at the Medicaid regulation, and I immediately confess I am not a Medicaid regulation guru here, I could not see where it set a formula, but I wanted to ask you, does the regulation establish a formula?
Not at all. I think the argument is actually that because
even if it could apply here, which I'm not saying it does, but even if it could apply, does it establish a formula?
No, not at all. And I think the argument is more because the program has to conform in loose regards with the federal program, or you risk getting your funds cut. It doesn't make it go away, that somehow becomes a formula. But there's a couple of really important points, aside from your Honor's point that it just doesn't square with Article 9, Section 22. And that is, first of all, under 42 CFR, Section 433.55.
Go slow, go slow.
Okay. I've never been able to stop my habit of fast reading in
You're speaking
25
fast,
years.
we're hearing slow. So,
42 CFR 433.55. That defines the tax that appellants rely on, but that defines a healthcare-related tax as a licensing fee, assessment, or other mandatory payment. So it doesn't work anyway, because that includes, in their definition of tax and assessment, the Arizona law, the flip side of that is under the May case, defines tax that could include assessment. But the second point, Judge Norris, is that Arizona had to obtain a waiver from Medicaid's requirement that health care related taxes be broad-based and uniformly opposed, because they cite to the waiver letter Arizona obtained. And that wouldn't have been necessary if Arizona's program met the definition of the health care related tax in the first place. So even if you want to go there, it doesn't help the appellants. And second of all, there's no way to read that as a formula or limit or anything like that. And I think you're right, Judge Norris, that the reference there is to the statute, the state statutes, and Judge Gerlach was correct in his observation.
Well, let me follow up on a question on that. You can tell me this may be a hypothetical, or you can answer it however you want. But if a state statute says, gives us and says pursuant to federal law, and we were putting the formula in the federal law, wouldn't that still be that would still be a violation of the constitutional provision, wouldn't it?
Well, not necessarily. I mean, one thing here, this statute specifically does not incorporate state law by reference or federal law by reference. It specifically did not do that. I mean, I suppose if your hypothetical were, it specifically said the definition of federal law governs here, or we follow that, and there was a formula in the federal law, that might be a situation that would look different. But in this case, there's not a federal formula or anything of the kind. And again, if you don't meet the federal criteria, what you do is risk losing some of your funding. It doesn't mean your program just stops or ends. I'm not sure if I answered your question, Judge McMurdy.
You kind of did. But I just want to make sure I understand your position clearly. So if the legislature, recognizing they couldn't get a supermajority, adopted or promulgated a statute that that said you have to do whatever it is, and the formula was in a federal statute rather than a state provision, doesn't that still violate the Constitution?
It's hard. I guess I can't object as incomplete hypothetical, but I think it's a hard. There could be a circumstance if a federal formula is incorporated or relied upon. I could see a circumstance where that would apply. But that's not the case here, and I haven't heard an argument that there's a formula under the federal law. I think the argument is, well, this is making up the difference between what the feds pay and the cost of the Medicaid program, but that's no different than in any circumstance. The university tuition's a good example. Tuition and fees make up the difference between the public and private funding and the budget for the university. So that doesn't create a formula. And there's three different criteria in C2. It has to be a fee and assessment authorized by statute, not prescribed by formula, amount, or limit, and set by a state officer or agency. So all three of those have to be met, and I think that's the checks there. And in this circumstances, there is not a formula, certainly under the state law and not under the federal law either.
But if they're, and guess are not prescribed by formula, amount, or limit, is that a state statute that it's referring to? Or
I think it's referring back to the authorizing statute. Fees and assessments authorized by statutes, not prescribed by formula, amount, or limit. And the briefs talk about examples of where fees are set. A statute says you will charge a fee of X dollars. And so that would be an example, although interestingly, in the Bidert case, even though the legislature initially set the amount of the levy at 1/4 cent a pound, it determined that it was not, under the first criteria, it would not be considered a tax because the commission had discretion and authority to change the assessment, whereas here the director has the authority to set it, to exempt people from it, to modify it, even far greater authority than the California Apple Commission had. Did I answer your question, Judge Norris?
You did.
So I guess I still have quite a bit of time left, but I think I've learned that I don't want to overstay my welcome. I think this is a situation where the exceptions of C2 definitely apply. Certainly, plaintiffs cannot overcome the constitutionality, the presumption of constitutionality, or the hurdles they would have to overcome on a facial challenge. The statute is constitutional. we would ask that you affirm Judge Gerlach's judgment, and I'm happy to answer any further questions you may have.
Did Mr. Hogan intend on saying anything to us today? You have 5 minutes. I'm simply asking. I'm not suggesting.
He's not jumping up from what I can see.
Thank you, counsel. Counsel.
All right, thank you. In the 2 minutes I have left, I just wanted to make a couple points. One, on the limit, we're not arguing that the federal limits here are formulas. It's that they establish a limit, which also falls under the C2 exception, because if you look at the face of the statute, the state statute, it specifically says that the assessment is subject to approval by the federal government and that it cannot be established or administered in a manner that causes a reduction in federal financial participation. That's an important limit. It's not a situation where if the director doesn't follow federal law, it just simply causes some sort of problem with the program. This is an explicit limit that the state legislature has placed into that statute, saying that these federal requirements are incorporated and the director must follow them. That is an explicit limit. And the fact that Arizona had to obtain a waiver, again, shows that there is a limit. And in fact, part of the reason that they were able to obtain that waiver is because, again, the program was still generally redistributive and still followed the general purposes or characteristics of a tax, of a program that wasn't collected with regard to whether the hospitals receive Medicaid.
But we don't really have to get there if we construe Section 22C2 and the provision that deals with that are not prescribed by formula, amount, or limit as specifying a state prescribed.
Well,
We don't even get there.
I don't think it matters, Your Honor, whether or not you construe that as being prescribed by the state versus the federal government, because, again, in this case, the statute explicitly adopts the federal requirements by saying that this levy is subject to the approval by the federal government and can't be established in a way that causes a reduction in federal funding. So, the statute, we don't want to read words into the statute. It certainly doesn't say state limit versus federal limit. Prop 108 doesn't specify. But even if you were to construe it as meaning the authorizing statute or the state statute, the authorizing statute here clearly says that the administrator has to follow the federal limits when he sets the levy. I see that I'm out of time, but if Your Honors have any other questions, I'd be happy to answer them.
Thank you, counsel.
Thank you.
All right. We appreciate the time you folks have spent getting ready for us, and we appreciate the information you've provided to us today. There is a benefit to oral argument, and it is largely ours, I think. But thank you for that. We're going to take the matter under advisement at this time, and we will issue our decision in due course. Counsel, again, thank you. We're adjourned.